An increasing number of esteemed constitutional scholars are making the case that as of this very moment, indictment or no indictment, conviction or no conviction, Donald Trump is constitutionally prohibited from running for president in 2024. But before we unpack all that, if you haven't yet, please hit that like, subscribe, and the alert bell. Maybe check out my Patreon. I'd appreciate the support. All right, folks, so what am I talking about? I think this is a pretty big deal. I'm seeing it constantly being retweeted or reposted on Twitter. It's making the rounds on MSNBC, CNN, the New York Times, the Washington Post, etc., and so forth. The situation is this. Obviously, Donald Trump is under an increasing number of indictments and prosecutions for his attempts to steal the 2020 election from President Biden, for the willful retention of national defense information and classified documents to which he was not legally entitled, the potential campaign finance violations out of Manhattan. I mean, he is in a legal nightmare, which is hilarious. But as many people have noted, based on the charges that he currently faces, Donald Trump could theoretically be indicted for these crimes, be convicted of these crimes, and yes, still potentially run for president and win the presidency, right? Because the crimes that he is potentially guilty of based on the indictments do not preclude him running from office, which again is silly and goes to show the vulnerabilities of what the founding fathers intended. We can obviously assume they probably didn't intend for convicted felons to be able to be president of the United States, but because it was never enshrined into law that, hey, if you're guilty of murder or if you're in prison for whatever X, Y, and Z, you can't run for the presidency. It's a loophole which is being exploited in bad faith by the GOP. However, as I said in the beginning, an increasing number of constitutional scholars, most of whom are conservative, most of whom are lifelong conservatives, lifelong supporters of the Republican Party, are actually making the case that the leader of the Conservative Party, the leader of the Republican Party, Donald Trump, is actually at this very moment constitutionally disqualified from running for the presidency in 2024. And this is what I'm talking about. We're talking about the 14th Amendment, Section 3. No person shall be senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or under any state who, having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of any state to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same or given aid or comfort to the enemies thereof. Okay? Basically, the too long didn't read version is if you took an oath to uphold the Constitution at a local, state, or federal level in any of the branches, and then you participate in an insurrection or rebellion, or you give aid and comfort to those who do, you can't run for office again. You are immediately disqualified. Now, this comes from, I guess, the initial trigger for this particular video is an article in The Atlantic written by two very different constitutional scholars. One is Professor Lawrence Tribe of Harvard. He's more of a liberal, progressive. He famously taught and advised President Obama, but he also taught Republican Senator Ted Cruz. He is an esteemed constitutional scholar. And then on the other side, on the right, you actually have Judge Ludig, who was a legendary conservative judge. He's retired now. He was a Republican supporter. He was an advisor to certain people in the Trump administration, highly respected by Republicans. And he was also one of the key witnesses under the January 6th committee because despite his lifelong advocacy for conservatism and the Republican Party, he's like, yeah, what Donald Trump did was incredibly illegal, incredibly corrupt, incredibly stupid. And so anyway, the two of them have actually analyzed the Constitution and the 14th Amendment in particular, and in addition to a very in-depth preprint study or legal essay by two conservative legal scholars as well, they've concluded that Donald Trump is disqualified from running for presidency. Now, I will play some clips here and let them unpack it. We're going to play it at 1.5 speed because there's a lot to get through, and these two are very old men who talk very slowly and deliberately because they do think about their words, so they're trying not to speak off the cuff or be too hyperbolic. So let Judge Ludig and Professor Tribe take it away.
In some ways, one of the most notable things that we say in the Atlantic article this morning is that George Washington, America's very first president, presciently foresaw and anticipated this moment in American history almost 250 years ago in his farewell address.
I actually do want to point this out real quick because, and I've mentioned this before in a previous video, this to me is fascinating. And one of the reasons why George Washington remains my favorite president, despite his many sins in terms of his statesmanship, what he contributed to this country, the Cincinnatus principle, how he I mean, he set the standard for a successful presidency, and he could have been a tyrant and chose not to be. But what's interesting is, in addition to decrying partisanship in his farewell address, he also basically prophesied the coming of Donald Trump in so many words. So the basis of our political systems is the right of the people to make and alter their constitutions of government. But the Constitution, which at any time exists, till changed by an explicit or authentic act of the whole people, is sacredly obligatory upon all. The very idea of the power and the right of the people to establish government presupposes the duty of every individual to obey established government. All obstructions to the execution of the laws, all combinations and associations under whatever plausible character, with the real design to direct, control, counteract, or awe the regular deliberation and action of the constituted authorities, are destructive of this fundamental principle and a fatal tendency. However combinations or associations of the above description may now and then answer popular ends, they are likely, in the course of time and things, this is the key part, to become potent engines by which cunning, ambitious, and unprincipled men, Donald Trump and people like him, will be enabled to subvert the power of the people and to usurp for themselves the reins of government, destroying afterwards the very engines which have lifted them to unjust dominion. So that was President Washington back in, it wasn't 1776. Why did I say that? It was back in 1796, okay, when he was leaving office for a second term. So he predicted this, right? But I want to go back to what Judge Ludig was starting to say.
Turning to the merits of what we have explained in this article, constitutional analysis, Ali, as you well know, does not lend itself to sound bites. In this case, though, it does, when coupled with the reading of this article that we've done this morning. And that soundbite is literally that the Constitution in Amendment 14, Section 3,
which we just read,
bids the former president from holding the office of the presidency again because of his conduct in and around January 6, 2021, and specifically in his conduct that either constituted an insurrection against the Constitution of the United States or a rebellion against the Constitution of the United States, or aid and comfort to the insurrection or rebellion that occurred on that fateful day.
So, yeah, they're basically making the case that Donald Trump, you could argue that Donald Trump fulfills all the criterion, that he engaged in insurrection and rebellion and gave aid and comfort to those who were attempting to do so as well. It's a really, really big deal. I do want to point out here, and again, there's so many excerpts that we got to cover. So this, again, is from the Atlantic article. Having thought long and deeply about the text, history, and purpose of the 14th Amendment's disqualification clause for much of our professional careers, both of us concluded some years ago that, in fact, a conviction, okay, so we're talking about, actually, let me play that particular clip right now, because they do make the case in this article that while Donald Trump's indictments are important, and he is entitled to the presumption of innocence until he's proven guilty in the indictments, this is an entirely separate situation, the disqualification clause of the 14th Amendment. There's no charge, there's no penalty, there's no punishment. Like, if you violate the 14th Amendment, it says nothing about jail time, it says nothing about a deprivation of rights. You do not have the right in this country to be president of the United States. You don't even have the right to run unless you meet certain qualifications. So I'm going to let Professor Tribe talk about this here, and then we'll dive into that paragraph.
A lot of people have become obsessed with criminal trials. It's all over television. You're presumed innocent until you're proven guilty. Yes, he's presumed innocent before we can decide otherwise in a court of law and inflict punishment. But that's why the framers of the 14th Amendment took great care not to treat this as a punishment. It's a disability. They call it that. It is not imprisonment. It's not removal from office and impeachment. Because it is not a punishment, because it is not a deprivation of any right or entitlement. Nobody has a right to be president without meeting the qualifications. It has to be applied in the first instance by an ordinary human being who is then challenged in court. What made you think this was an insurrection? The Constitution uses the term insurrection over and over again to make clear what it means. What it means is an organized effort using all means available, up to and including violence if necessary, to prevent the government from performing its functions for the American people. And one of those central functions is the peaceful transfer of power from one president to the next. So I think that any Secretary of State operating without any partisan motive, whether this was Donald Trump or any other president who did it, would have to conclude this was an insurrection, and at a very minimum, he gave it aid and comfort when he decided to let it continue, when he cheered it on, when he pointed a finger of blame at the embattled vice president in the face of the gallows that had been constructed.
Because that's an important part right there, too. Remember, set aside, perhaps you might be particularly inclined for whatever reason to give Donald Trump super charity with respect to the incitement part. But the fact of the matter is we know he watched the insurrection unfold for 3 hours. And as the chief executive of the United States, as the commander-in-chief of the military, as the person who is, even more so than the attorney general, the ultimate law enforcement officer in this country, who has an obligation to suppress violent uprisings and insurrections, he allowed it to happen for 3 hours. That is, by any reasonable definition, giving aid and comfort to the enemies of the United States in their capacity of engaging in an insurrection. So basically, Professor Tribe, without so crassly saying it, is Trump is screwed no matter what, even if you don't think he himself directly engaged in insurrection or rebellion. The fact of the matter is he did verifiably give aid and comfort to them. So that's really important. So with that in mind, they're talking about a conviction would be besides the point. The disqualification clause operates independently of any such criminal proceedings, and indeed also independently of impeachment proceedings in congressional legislation. The clause was designed to operate directly and immediately upon those who betray their oaths to the Constitution, whether by taking up arms to overturn our government or by waging war on our government by attempting to overturn a presidential election through a bloodless coup. And the article in question, because again, they're citing the scholarship. In addition to their own independent constitutional analysis, Professor Tribe and Judge Ludig are citing constitutional scholars who are William Bowdy and Michael Stokes Paulson, okay, because they wrote a piece, which we're about to look at here. We were immensely gratified to see that a richly researched article, soon to be published, that's what we're about to look at, in an academic journal has recently come to the same conclusion that we had and is attracting well-deserved attention outside a small circle of scholars, including Jeffrey Sonnenfeld and Johnny Jane of the Yale School of Management, whose encouragement inspired us to write this piece. The evidence laid out by the legal scholars William Bowdy and Michael Stokes Paulson in the sweep and focus of Section 3, available as a preprint, again, that's what we're going to look at, is momentous. So these are two of the most prominent conservative constitutional scholars in America, and both are affiliated with the Federalist Society, making it more difficult for them to be dismissed, as they will attempt to be. People will attempt to dismiss them as political partisans. Not only are they conservatives, they're affiliated with the Federalist Society, which is about as conservative and Republican-based as it gets. Thus, it is all the more significant and sobering that they don't hesitate to draw from their long study of the 14th Amendment's text and history the shattering conclusion that the attempted overturning of the 2020 presidential election and the attack on the Capitol, intended to prevent the joint session from fairly counting the electoral votes for the presidency, together can be fairly characterized as an insurrection or rebellion. Okay, they write exactly what Professor Tribe and Judge Ludig say. Our second point is colossally important, a major sticking point for some, but it is a point that we think should be obvious. Section 3 of the 14th Amendment is self-executing. That is, its disqualifications from office are constitutionally automatic whenever its conditions for disqualification are met. Nothing more needs to be done in order for Section 3's prohibitions to be legally effective. Section 3 requires no implementing legislation by Congress. Its commands are enacted into law by the enactment of the 14th Amendment. Where Section 3's legal rule of constitutional disqualification is satisfied, an affected prospective office holder is disqualified automatically, legally. Now, of course, this is not we're not in an episode of Supernatural. We're not in Harry Potter. This is not a magical contract per se, so it's not like things are instantly prevented. So you might think, okay, well, what would that look like, right? Well, essentially, the case is that Donald Trump, because he violated he met the disqualification standards provided in Section 3 of the 14th Amendment, Donald Trump is as effectively disqualified as somebody who's trying to run for president who isn't, number one, a natural-born citizen, and number two, 35 years old. So I'm not 35 years old. If I tried to run for president, the Secretary of State in whichever state I attempt to file the paperwork would just say, no, you don't. You're not 35, right? You're a natural-born citizen of the United States, but you're not 35, and that's a requirement. So it would be up to, effectively, election administrators, and in particular, the state Secretary of State, to say, no, you don't meet the criteria to be president at this time. It's the same thing for Donald Trump. And as I think Professor Tribe either said or was about to say, let's see.
He gave aid and comfort to the enemies of the Constitution of the United States. And to put a icing on the top of that, rather,
it would have to be challenged, right? So the idea is that if a state Secretary of State enforces the disqualification principle of Section 3 of the 14th Amendment, it would inevitably be challenged in court, right? Because, of course, MAGA and Trump loyalists would be like, this isn't fair. So they would sue the state Secretary of State. And they would say, hey, the state Secretary of State says Donald Trump is disqualified by the 14th Amendment. What does the court say? Does the court agree? And as Professor Tribe talks about in this interview, it would make its way up to the Supreme Court. Then, of course, it becomes a complicated issue because it's a 6-3 conservative supermajority. So the liberal justices would almost certainly agree with the common sense interpretation. Like, yeah, he engaged in insurrection, he engaged in rebellion, but even if for whatever reason you want to be absolutely stupidly generous to this man, and you're not obligated to be, but if you choose to be, he factually gave aid and comfort to the enemy. There's no alternative reasonable interpretation of this. However, then you have the other 6 justices. And the problem is 3 of those 6 were confirmed, nominated and confirmed by Trump and Trump-supporting Republicans. So you have Kavanaugh, you have Gorsuch, and you have Amy Coney Barrett. And then the 3 conservatives who were not confirmed by Donald Trump are Chief Justice John Roberts, Samuel Alito, and Clarence Thomas. And so you might think, well, those 3 are not loyal to Trump. I mean, or certainly wouldn't be as beholden to Trump since they weren't nominated and confirmed by him. And I would certainly agree with that in terms of Chief Justice Roberts. I could see him easily. I would not be surprised at all if he concluded the way that Professor Tribe and Judge Ludig and, again, these various constitutional conservative scholars agree. But Alito and Thomas are crazy. They are as irrationally conservative and activistic, perhaps even more than the Trump appointees, ironically. Like, if not for their loyalty to Trump, or if not for their potential loyalty to Trump since he nominated them and had them confirmed, I actually would trust Kavanaugh, Gorsuch, and Amy Coney Barrett to be more inclined than Alito and Thomas because they seem to be more sane in general. So there's no telling how it would be adjudicated if it got to the Supreme Court. Professor Tribe and Judge Ludig and others are actually fairly confident, or seem reasonably confident, that even this regressively conservative Supreme Court would manage to secure a majority. And to be fair to this regressively conservative Supreme Court, there have been times that they have ruled against Trump. They did not want to take up Trump's 2020 election challenges whatsoever. They're like, hell no, we want no part of this, right? So it's not like they're always beholden to him, nor should they be, because they have those offices for life. They don't need Donald Trump's approval to remain Supreme Court justices. So if they had a modicum of integrity, if this case, if this happens, if state secretaries of state or state election officials are successfully persuaded by this, and like, yeah, this self-executing principle of the 14th Amendment disqualifies Donald Trump, so we're going to keep him off the ballot. If there is a legal challenge to that, and it makes its way to the Supreme Court, perhaps they would secure enough Supreme Court justices to go, yeah, this is sorry, Donnie, I don't need your permission here. You did cross a line. You are disqualified. But who knows? The point is, I think it's really fascinating that these scholars have come to this conclusion. Now, I will also point out, and I have so many links here. Sorry, it's hard to keep track. But as they note, as Baudet and Paulson note in their article, there is going to be questions about how this manifests. So the former federal judge and Stanford law professor, Michael McConnell, cautions that we're talking about empowering partisan politicians such as state secretaries of state to disqualify their political opponents from the ballot. If abused, this is profoundly anti-democratic. He also believes, as we do, that insurrection and rebellion are demanding terms connoting only the most serious of uprisings against government, and that Section 3 should not be defined down to mere riots or civil disturbances. McConnell worries, and again, not Mitch McConnell, Michael McConnell, worries that broad definitions of insurrection and rebellion, with a lack of concern about enforcement procedure, could empower partisans to seek disqualification every time a politician supports or speaks in support of the objectives of a political riot. That is a legitimate concern. It's basically the slippery slope, but fair enough. And, again, it's not like these are divine contracts which are divinely enforced. All of the words written in the Constitution, from the Bill of Rights all the way down to, I don't know what amendment we're on, are we the 27th Amendment? Have to be, and they were written, number one, by people, no matter how brilliant, flawed people, right? Many of whom are no longer with us. It has to be interpreted. Those words have to be interpreted by very flawed people, each with their own biases and agendas on the left and the right. So there is serious potential here, given the I shouldn't say surprising, but given the ever-increasing lack of good faith in this country. It's certainly possible that a slippery slope could be created here. And as Professor Tribe and Judge Ludig point out, we share these concerns, and we concur that the answer to them lies in the wisdom of judicial decisions as to what constitutes insurrection, rebellion, or aiding comfort to the enemies of the Constitution under Section 3. So, there are some complications here. This would be a game changer, and you know that bad faith Republicans and bad faith conservative secretaries of state in particular might be inclined to take this and run with it to appease their constituency, or because they themselves are just genuinely personally loyal to Donald Trump. There's potential for abuse here. But I got to say, I find the arguments at least very compelling in this article and in the constitutional analysis. And I also want to point out a couple more things before we conclude. Professor Tribe and Judge Ludig point out, if Donald Trump were to be reelected, how could any citizen trust that he would uphold the oath of office he would take upon his inauguration? As recently as last December, the former president posted on Truth Social his persistent view that the last presidential election was a massive fraud and one that allows for the termination of all rules, regulations, and articles, even those found in the Constitution. No person who sought to overthrow our Constitution and thereafter declared that it should be terminated and that he should be immediately returned to the presidency can in good faith take the oath that Article 2, Section 1 demands of any president-elect before he enter on the execution of his office. Okay, it's a really good point. How could we trust a damn thing that this man says? So some other things, I promise you we're going to wrap up here, and there's so much. We could probably spend like 3 hours on this. But there is some precedent. Even recently, even since January 6th, because of January 6th, 2021, the attempted insurrection, where Section 3 of the 14th Amendment has been enforced by a person who actually was in office. From an example of how this process is supposed to work, consider how the state of New Mexico removed Commissioner Coy Griffin from state office. Griffin was an elected commissioner for Otero County, New Mexico, who promoted, assisted, and ultimately joined in the January 6th insurrection against the Capitol. A group of New Mexico citizens filed a quo warranto action, sorry, I don't have my glasses on, against Griffin under the New Mexico law, seeking his removal from office. This was widely publicized, and then I think most people forgot about it ever since. But it's an immediate precedent. The New Mexico District Court took evidence, received legal arguments, and then concluded that Griffin was disqualified under Section 3 of the 14th Amendment. More precisely, and quite correctly, it held that Griffin had been disqualified since the day of the January 6th insurrection and ordered his immediate ejection from office and permanently enjoined him from seeking or holding any other covered position. As a matter of state procedure, the court concluded that the New Mexico quo warranto statute was a remedy for ejecting unlawful office holders. It also concluded that quo warranto could be sought by any citizen of New Mexico. So the means by which these citizens applied to have Griffin removed from office because of his participation in the insurrection, New Mexico held any citizen has a right to do that because they have some sort of injury, without any further showing of injury, because the New Mexico courts are not bound by the same standing limitations as the federal courts are. Okay, now so there's a distinction there between state court and federal court, but in New Mexico, the New Mexico courts essentially made the case like, yeah, if an office holder or a potential office holder is disqualified by the 14th Amendment, then they are harming their citizens because their citizens have a right to not be represented by a person who violated the 14th Amendment by being under the power of someone who is disqualified to hold the very office which gives them that power in the first place. So it's fascinating stuff. I'll also point out there's an entire section. Again, this is a vast article, 126 pages, and it's in preprint. It's available. I'll probably include the link on the in the description of the video. But they have an entire section dedicated. Section 3 disqualifies Donald Trump from future office. This is not about Donald Trump. This is a scholarly article about Section 3 of the 14th Amendment, and then Donald Trump is mentioned at the very end. He's just the foremost example to these conservative scholars. The case for disqualification is strong. And you know most of this, they provide it in very concise and very persuasive legal terminology to kind of collate the information. I won't go through it all because, again, you're aware of most of the facts. But, folks, I highly recommend that you take a look at this. And, again, I know it's like we're approaching 25 minutes at this time, and I'm sorry for dragging it on, but this is really, really important because, again, these legal scholars, these constitutional scholars, most of whom are of conservative background, right? So it's not like they're partisan political hacks, they're part of the Democratic deep state. No. I mean, of course, MAGA is going to say that, but they're lying, okay? These are actually people who would probably, in a roundabout way, are actually arguing against their interests in certain respects. Like, you could make that argument because they're arguing against people who violated the 14th Amendment on their side, right? Who would perhaps pursue agendas and policies and philosophies that they support, right? They are taking a principled stance here. They're like, look, these are people on my team, and I'm saying that the Constitution disqualifies them. And they make an incredibly persuasive case. Now, again, there are going to be legal challenges if any state secretary of state boldly chooses to act on the truth here. But honestly, I can't see really one good reason why it's not worth pursuing besides the potential for abuse. But if that's the case, then we are paralyzed by action. There's no remedy for anything, because the truth is, in politics and law, and certainly where the two intersect, such as a situation here where you have a president or former president running for office who may have violated the law, and he's a political leader of one of two major parties. I can't imagine a more intimate intersection. There's always going to be the potential for abuse. People are making that case with indicting Donald Trump. You should essentially stop indicting Trump. You should stop trying to hold Trump accountable because there's a potential for abuse. What if Republicans, when they take power, go to investigate their political enemies, even if those political enemies actually they don't merit an investigation? That's certainly possible. But if that's the case, then we don't have a rule of law. And if we don't have a rule of law, do we have a country?